waiting for you two. There it goes. Okay, we're live.
All right, we will call to order this meeting on March 1st of the Woodford County Board of Education. Let the roll call indicate that all 5 members are present. Ms. Richardson, are you able to hear us?
Yes.
All right, thank you. There are 4 present in person. I'm sorry?
I can hear you.
Okay. Ms. Cooper, is there any public comment?
Not this time, ma'am.
All right, no public comment, so we will move on to our work session agenda, which includes beginning our school board attorney interviews. And our first interview is with Ms. Combs. Welcome, and we look forward to talking with you.
I look forward to talking with you also.
We have 11 questions that we're going to ask each candidate, and we've allowed 30 minutes for each interview, just to give you kind of a parameter of what we're looking at.
Okay.
And we'll also give you a little time to do an introduction to kind of introduce yourself to the board. As a board, I think we need to figure out how we'd like to ask the questions, if we want to go around and have different people ask questions, or with one of us virtual if we want to do one person. Does anyone have any comments on that? Ms. Springate?
No.
Ms. Richardson?
I think it would just be easier, Madam Chair, if you asked each question for us.
Okay. Ms. McCann?
That's fine with me. It doesn't matter.
Ms. Glass?
I think that's good.
Okay. Mr. Hawkins? A preference?
Go ahead.
All right. All right, Ms. Combs, we'll get started if you want to go ahead and tell us a little bit about yourself.
Okay, I started my practice actually in Eastern Kentucky, where I'm from, up on the Virginia border. Did attend University of Kentucky Law School, attended Pikeville College, went back there to practice law in Whitesburg, Kentucky for 8 years of my legal practice. Represented the 2 local school boards there. Also did a lot of federal court work, a lot of it for school boards, have represented a lot of businesses there. Then moved, my husband transferred into Lexington, and I was in-house counsel for the Fayette County Public Schools for 4 kind of long years. Their work weeks were kind of long. They had a lot of extra board meetings and things of that nature. Was recruited then to go to the Kentucky School Boards Association, primarily to work with special education law, because that was the area of law they were getting sued in. But while I was there, I also was the backup general counsel for Steve, and then moved, as you'll see from my resume, up to actually be the director of legal services, and implemented a lot of extra trainings and that kind of thing in the areas of personnel, and did some board training as well. And then I went back out into private practice, actually with the firm my daughter was with, who was an attorney. Moved from that firm to another firm with her. She liked that firm better than I did, and so I'm back at the firm actually where she started, when she started practicing law in Lexington, with my good friend Guy Colson, who's been represented Berea schools for about 25 years now, and is kind of a staple amongst lawyers in Lexington. So that's me. I've lived in Lexington now since right around the time of Kentucky education reform, so I saw all that develop. You know, I have worked with a lot of states also in my role as an administrative lobbyist at the Kentucky School Boards Association. So I know how to interact with a lot of those agencies, and I like working with educators, and I think I'm pretty good at it, and getting things down into the terms so that they understand what it is they need to be doing to stay out of trouble.
Very good. All right, we will go ahead and get started on, well, we've kind of handled a little bit of question 1, but we'll give you a chance to add anything that you might like. Question 1 is discuss your qualifications and experience.
Okay, I actually, the first I was a very good student. First of all, I clerked actually every summer. I actually clerked for a judge. I clerked for a Commonwealth attorney. They actually recruited me to work for them. I was lucky enough to get my name in the newspaper every once in a while, so they knew I was making good grades in law school. I actually did a pre-law internship in Pikeville before I even got into law school. And then the fellow that I did my first law practice with, I interned for him one summer, and that's how he liked my work well enough that he hired me to do that. And then the move to Lexington, Fayette County Public Schools was looking for a board attorney, and I just happened to have moved here because of my husband's transfer. I liked working with educators. I had a lot of background with education law. You folks probably know there's not a lot of people around who do public education law, school law. It's kind of there's a lot of federal and state legislation. They love to legislate about schools, and you also have to know a lot about employment law, even employment law that doesn't affect schools, like Fair Labor Standards Law, wage and hour things, Americans with Disabilities Act things. And so I know a lot about those things. The 4 years that I spent in-house in the Fayette County schools, I know how to find anything in a school district at this point. From the financial standpoint, I know all the questions to ask, every place to look for what kind of answers I need. I did all kinds of things there. I worked with the personnel office, of course, worked with the board, with board committees, interacted with state agencies and still do a lot of that, like the Department of Criminal Justice. KDE, I worked a lot with the regulations that KDE writes, have written through the years, like restraint and seclusion. That was one of the big regulations. Of course, worked with them on the special ed regulations. I wrote the special ed procedures that your district is using, and a lot of districts in the state are using, almost every district, I think. I know I've done a lot of personnel work, just employment law work, a lot of classified discipline, corrective action plans, trying to help teachers get better so we don't have to fire them, or ultimately, if we do, to do that. So I've done a little bit of everything that a school district attorney would do. You know, I represented them in unemployment appeals if a teacher did something really bad, or if a bus driver did something really bad, like left a kid on the bus. And I kind of know how it all fits together. I was one of the first attorneys in the state to actually train for school-based decision-making training, so I understand how that interacts with the board. I had worked with the Education Professional Standards Board. I've chaired one of their committees on inappropriate relationships between staff members and teachers. And so I think I'm very well qualified. I have a few general counsel districts that I'm general counsel for now. I have a few more than that even that I am counsel for in the area of Americans with Disabilities Act disability law, and they pull me in to do personnel work. Because sometimes your local attorneys are not as versed in the federal law as I am. And so constitutional law was always a biggie for me, and because you're a government entity, that's always a big issue. Have people been given due process? You know, I've done all kinds of student discipline work, for kids that are not special ed or 504, kids that are special ed or 504. You know, and having done all the work with the state agencies, I know how to contact people and how to do workarounds for things that you need. I also represent a couple of educational co-ops in Kentucky, and through them to interact with a lot of state agencies and how funding is moved through and that kind of thing. I am good in working with people that respond to me. I've done trainings over the years on various issues, and people tell me that I'm a good trainer, and they do seem to understand what I'm saying. I think I'm able to kind of bring down the law to the level of practical. I try to be very practical in the approach, brainstorming with administrative staff. This is what we need to do to be in the best legal and defensible position we can be in. I don't tell administrators what to do. I don't tell board members what to do. My role is to advise on the legalities and what can happen if you make this choice rather than this choice over here. And then it is your decision to weigh and balance that, and to try to guide you through to, you know, make your step and you as comfortable as you can be that you're doing what will keep you out of trouble. and letting you know that you know, that is your choice and what the repercussions could be one way or the other for those decisions.
All right, thank you. Next question is, how many districts do you currently represent?
Oh, I've got my little list here. Actually, we represent Berea. That's mostly Guy Colson. He's had that for 25 years. And I represent Russell Independent Schools, Frankfurt Independent Schools. So that's a couple for me. I am second general counsel for Jessamine County Schools. They still have a gentleman that comes to the board meetings and that kind of thing. He's getting older. I'm general counsel also for Rockcastle County Schools, for Rowan County Schools. So for general counsel work for me, about 4 that I am the first line general counsel for. And then there is about 5 more that I am second general counsel for, or do personnel aid work. Because a lot of times, you know, the local board attorneys, yeah, they can come and shepherd you through a meeting with the open meetings and that kind of thing, but they, because they have private practices that do other things, they can't delve into the depth and the breadth of the school law that I've been able to do for the 20 years I worked at the School Board Association. And then I have that in-house work at public schools. I have the work for 2 local districts before I went to Fayette County. The districts I represent now are mid-sized to small. So I have that kind of a real breadth of experience. It's kind of unique amongst school board attorneys. I've also done litigation, a lot of litigation, mostly in federal court.
All right. The next question is, how do you define a successful partnership between the board attorney and the school board members, the superintendent, and district staff?
Well, board attorney's first obligation is to the board as an entity, okay? And that's always my first obligation on personnel matters. It's to the superintendent, because we know that except for administrative demotion hearings, the board cannot have any, cannot tell the superintendent what to do in personnel issues. So I like to have a clear line of communication of what is the board as a body, who is going to be the contact person for me on their issues, on personnel issues, because first of all, I want to get paid if I have to spend a bunch of time researching something for a board member. So I want to know that the board has blessed that as being something that all the board members want me to do. I don't represent one individual board member. My ethical obligations are to the board as a whole, and on personnel issues to the superintendent. And I have that very clearly defined relationship. That is a good relationship for me, is to know clearly for me who I'm to be communicating with and what I'm to be communicating about to whom. That is a really good relationship. With school staff, I don't represent individual staff members, except to the extent they are acting on behalf of the superintendent or the school board in some way. And if there is some kind of a conflict between them, then, my first obligations are always to the board and the personnel matters to the superintendent. So I like to have an open, honest relationship, because there are times when people have to be talked down. And I do that in a very nice way, I think, and try to bring it down to a very relevant point of what could go wrong here. This is the law. Maybe you have some discretion here, but where you have discretion, be careful with your discretion. And I need to be able to say that to people and not have them get mad at me, because I would have no personal reason to say it. I'm not a resident of Woodford County. I don't vote over there. I don't pay taxes over there. And I'm looking at it very objectively, is how it's judge going to look at it. And so I like to have clear communication, and I like to be able to have an open conversation with the person. If I have a conversation, however, with the superintendent or with individual board members, that's also confidential. I won't be talking about that to everybody. That'll be up to you folks to share that with each other if you want to do that. So I like the clear communication, and I like honest communication. Your attorney cannot help you if you're not honest with me. My communications with each and every one of you that I would talk to, the board and the board members and the superintendent, are confidential. And when I have conversations with administrators, if they get in trouble or something looks like it's going wrong, I always say to them, you do understand that what you tell me, I may have to tell the superintendent of the board, depending on what it is, because that is where my ethical obligation lies. But I need to tell you that, before we have this conversation.
All right. Next question is explain your billing process, including your rates, kind of your timelines, contracts, and any other specifics that you think might be helpful to us.
We bill you on a monthly basis, generally, unless we have some other situation. Quite honestly, if it doesn't get to a few $100s, a lot of times we won't bill that until maybe the next month, unless you folks want us to. Those bills will come to the superintendent. They are billed at 1/10 of an hour or 6 minutes per, or a portion of 6 minutes. I have you now. I think I sent maybe a sample engagement letter to Superintendent Hawkins, and I have that down to offer you $160 an hour rate, because your district belongs also to a subscription service I have, and pays a small retainer for your staff to belong to the special education service that I give to a lot of districts in the state. And if in fact you did not belong to that service, it would be $175 an hour, but I have you for $160. If in fact you wanted to join for your human resources people, which I have about 30 some districts that have joined, my Americans with Disabilities Act and Family Medical Leave Act, where you get as much advice as you want from me for a year on those topics for $600, your hourly rate would go down to $150 an hour. And of course, I'm close to you, so travel time, we do bill at the hourly rate for the travel time, but I'm not 10 or 15 minutes from you. As far as traveling out there, we do bill at the IRS mileage rate for that. And we do not ask for a retainer up front. I mean, you basically pay me a little retainer for the special ed right now, and I only bill you what I work for you. You won't get billed for every little short conversation or something, something saying come out and do a training or something like that. But anything that takes, much research, much thought, much conversation with you, you would get an hourly bill for. We also have built into our contract that we have runners and research assistants and things like that who would bill at a lower rate, which is in the letter I think I sent to you all. I don't know. I was going to try to pull one out here. I just sent one to a district today because I'm going to do some on-site special ed work for them. And I don't know why I don't have that engagement letter. But everything that I billed you for, you would know what it was. If it was postage, mileage, phone calls, of course, long distance faxes, all that, that's all pretty much the same now. And I could actually pull out an engagement letter and give you those numbers if I were at a better location. Hang on.
That's okay. That's okay. We all received that from Mr. Hawkins, so thank you very much. All right, question 5. How will you ensure all members of the board are kept informed, and especially in matters where there is a divided board?
I do what I used to do when I was in-house counsel for the Fayette County Public Schools. When I would give them litigation reports, I would do a memo, and every board member would get the same memo. Because, of course, with open meetings, you can't all get together and let me talk to you unless we have some kind of pending litigation. And so what I would do is to inform you is I would do a memo, and it would be emailed to each board member the same.
Okay. How many superintendent contracts have you assisted in negotiating, and what is your level of comfort in doing so?
I'm comfortable with that, and I think, of course, I did one in Fayette County, and I don't think anybody else has ever asked me to do that, but I'm very comfortable with that. Okay. Because again, the superintendent's there. The superintendent knows that I'm first and foremost the board attorney when you folks engage me. And so if the superintendent felt to need to get another attorney that I needed to interact with, that would be fine. But I have a good comfort level with that. I know what you can and can't put in there, basically.
Okay. Question 7 is, how would you describe your communication protocol with your school board clients when you have pending litigation or open matters? Would you say you're easily accessible to your clients?
I'm very easily accessible to my clients, and even if I'm doing a training, which I do a lot of in the summers for a lot of districts, I try to at least get back to you within a 24-hour period if you have a question about something. I might ask you, how important is this? Even if I'm on vacation, I always, if my clients email, text me, I will try to call me. I will listen to the email or the voicemail and say, how urgent it is, can it wait? But I always try to get back to you within within a 24-hour period, we might not get all the answers then, but at least to let you know I'm working on it, to get the timeline. If you say it's urgent, I call you no matter what I'm doing. I will, try to get a break if I'm in a hearing or something and step out and call you, because I know how things can happen in a district, and they can happen pretty quickly sometimes. You have some student disciplinary issues and sometimes some staff issues that can be troublesome. When I was in Fayette County, they actually had me doing a litigation report periodically of what was going on. Of course, most of that's handled by insurance counsel, outside counsel, but you're wise to have your local attorney at least working with those attorneys, because the attorney knows more what they should be doing, than you all do, as far as what's going on and how they should report back to you and all those kind of things. So I make that, like I say, I'm very accessible. I try to keep an eye on that if that's something you want me to do. Now, some boards say, oh no, we don't want you to spend time dealing with those outside attorneys, other than to write an audit letter, once a year about the litigation. If you want, if you wanted to see, I used to give them a yearly report, like this is what this is about, even if it's a personnel issue, this is where we are in the process, this is kind of the outlooks like what might happen, kind of that kind of thing. But whenever you wanted it, you would get it. I would make that work for you, because I'll tell you, I'm an attorney. I work when you need me to work, because that's how it goes in school districts. People call me during graduation time. They're always calling me about things like who can bring a service animal in on a Saturday.
Sure.
Not too many hours go by that I do not check my voicemails and my texts and my emails.
All right, thank you. Number 8 is, do you have experience with new to a district superintendents and helping them to acclimate to the policies and procedures of the district?
I absolutely do. I have a new one this year in a district that just hired me, and we're working through it very well. I think she's paying a lot of attention. I put a lot of my time into being sure they know that they're supposed to be following board policies and how to easily access those, because while the superintendent does have control of discipline over personnel, the board is the actual employer, and the board has all the policies about how people are paid, what kind of leaves people can take, all those kind of things. And that's the biggest thing. I'm sorry, my other phone's ringing, but hopefully my husband will grab that. This from home. You can see his animal pictures up here. New superintendents, I'm a good trainer, legal trainer, and that stands me in pretty good stead with new superintendents. I actually have assisted the Superintendents Association in past years when I was with the Kentucky School Boards Association for several years with training new superintendents. And so I kind of know, and you'd be surprised what even more seasoned superintendents need as far as hand-holding sometimes. It just depends on the experiences that people have had, what they've been through, how much training they've been to. But yeah, that's something that I'm very comfortable with. And I think too, now that I'm getting a little bit older, that my advice, they welcome it a little bit more maybe than if I were younger. So I think that, people say to me as clients, I don't always want to hear what you tell me, but I trust that you're telling me good options for me, and that if I'm getting ready to make a bad choice, you tell me that too. And I don't always like what you have to tell me, but I trust that you're looking out for my best interest. So I have a reputation for being very ethical.
Good.
And very knowledgeable.
Good. All right, thank you. The next one is, when working with parents and guardians, as well as adult students, what's your experience in directly supporting ARC team members in meetings to resolve concerns and conflict? If an ARC is unable to resolve the conflict or concern and a formal complaint is filed, what is your experience in meeting regulatory timelines?
Well, since I'm known for my special ed expertise, so to the extent that sometimes people forget I've been a board attorney, I have even more districts than the 7 or so that I have, that I do general work for, that hire me just to come to ARC meetings when they have a troublesome attorney on the other side or an advocate. And I find that you have to be nice to parents if they'll let you be, and I encourage the administrators and teachers to all be nice to parents. But at the same time, I think we have to get it across that these are educated individuals here who have the interest of your child at heart. And many, many times I have been able to counsel the chairs and the special ed director to coming up with something that will make the parent happy so that they don't feel the need for their attorneys and their advocates that much. And I've been very successful with that. I've handled a bunch of hearings. I used to represent an insurance company that I don't represent anymore, but I did a bunch of hearings for them, and the tack with the parents is always very different than if you have some adversary from the outside who comes in to sue you. You know, even your attorney is not going to be mean to the parents. That's your clientele, and there is a certain way you can deal with that, and I'm very comfortable with my expertise in that area and what we can and cannot do. And so I think I give a comfort to the administrators, and they, you know, sometimes I might say, but they've been really nasty to us, and I say, well, but that's not our role to be nasty back to them, although being nasty and holding the line are two different things, and sometimes we have to hold the line to do what we know we need to do. And I fully understand about timelines, and Kentucky Department of Education, I have filed responses on behalf of districts to many, many KD complaints, and understand all that quite well.
All right. The next one you've kind of addressed, but we'll go ahead and go over it. Given the issues often arise unexpectedly that need attention, generally speaking, what is your availability to respond to school district personnel questions?
Yeah, just daily. You know, even if every once in a while, like this summer, another attorney pulled me in to help him with a termination hearing because of my expertise in the Americans with Disabilities Act. But even through that, you know, every couple of hours or so, I would watch my email and would at least tell somebody in my office, call and find out if they can wait till tomorrow to talk to me, or I'll call you after hours. That's not a problem for me. You know, I don't punch a time clock. So I work when people need me to work. Somebody emailed me, when was that? Today's just Monday, right? So that was last night. One of the special ed directors emailed me actually about a personnel issue and about a special ed issue, and I responded back to her last night, and then she and I had a conversation this morning. I mean, I think if you talk to anybody in a district, that being accessible and understanding that sometimes things are urgent, or just that people need to talk to you sometimes, you know, and you can't put them off for weeks. People will tell you that I'm very responsive. I think that's one of the higher praises that you will hear from people about me.
That's great. And our final question that we had prepared is approximately how much of your professional time is dedicated to school legal issues?
All of my professional time, except for 1% with my 2 education co-ops, because they get involved in different things like federal contracts and things that I have to research. And I do represent also the Kentucky Academy or Association of Academic competition. Other than that, all my other clients are school districts.
All right, very good. We have a few minutes left here. I'd like to, if it's okay with other board members, I'd like to ask our district employees if they have any follow-up questions that they would like to ask before we do. Mr. Hawkins? No? No? Mr. Wells? All right. Then we'll go around to the board members. Ms. Springate?
No, it sounds like you have just your entire career has been spent with education, and that is just very fortunate for districts to be able to have that level of expertise. So thank you.
All right, thank you. Ms. Richardson?
I'm good, thank you.
All right, Ms. McHale? And Ms. Glass? No questions. All right. Well, again, let me be the one to say thank you so much for all of your time and the information. I would also agree with Ms. Springate. It sounds like you have lived a long time in the school world of law. So thank you for your service, especially to our students with different abilities and disabilities. As a parent and a school board member, that's always appreciated.
Thank you.
All right, thank you so much.
Thanks, Teresa.
Thank you. Bye-bye.
Bye-bye.
Hey, Allison, we have another feed for the next interview. That way we kept them from crossing each other. So we'll have to close this one out and open that link up, okay?
Okay, are we gonna go ahead and start with Grant, or does it start at 6:45?
That's up to you all.
If he's available.
Either way is fine with me.
Yeah, if he's available, yeah, let's go on to that link, and if he's available, then that might be good.
Okay, perfect, I'll see y'all in a minute.
All right.
very well.
Yeah, he's here now. Hello, Grant.
Hello.
Allison's not back up there yet.
All right, we'll wait for her.
Let me get this one up there.
All right, Ms. Richardson, are you able to hear us?
Yes, ma'am.
And Mr. Chenoweth, are you okay to hear as well?
I can hear you fine, thanks.
All
Can you hear
right.
me?
Okay, well, we will go through the same kind of introduction. Obviously, Mr. Chenoweth, you're well known to all of us. We've prepared some questions that we're going to ask all of the attorney candidates to go through. We've got 30 minutes allocated for each interview, and we have 11 questions. If you want to start out by giving an introduction, then we'll move on to the questions.
Thank you. Yeah, I was talking to somebody earlier today, and I said this a little bit felt like I'm a salesman describing to you the handling of a car after you've returned from the test drive. I don't really know what I can say that you haven't already figured out as to what I offer and how I try to serve my clients. I have served Woodford County Board of Education the entire time I've been practicing law, which is working on 13 and a half years now. Even before that, I worked for my dad as he worked to represent public school districts, including Woodford County, dating all the way back to 1985. So when the law office closed last fall, I completed my 27th year of employment for the Chenoweth Law Office, having started with them when I was in high school as a honest to goodness, on the books, paid above the table employee, going through old files and things this weekend to keep working on sorting what needs to be saved and what needs to be shredded. I actually came across my very first timesheet that showed a couple of hours of work on January 2nd of 1994. And my mom had written, as the office manager in the top corner, she had written my hourly rate and that they had to withhold taxes off of that timesheet for the first time. But because of the nature of growing up in a law firm and my dad having had the history of working in the Attorney General's office, writing opinions on education issues, it just really is all I know. I have represented a couple of private schools and done a little bit of work for fiscal courts on insurance defense matters. But well over 95% of all of the work that I've done as law clerk and paralegal and now practicing law has all been focused on representing public school districts, their employees, their administrators, on personnel matters, student matters, property matters, litigation, just a little bit of everything that we're asked to do. So that has been the sole focus of my career, and I've had the good fortune of being able to represent you all the entirety of the time that I've been an attorney.
Very good, thank you. The first question, and you touched on this a bit, but we'll give you a chance to expand if you'd like, is discuss your qualifications and experience.
One of the things that, beyond just, I'm an attorney, that's been my field of practice, and that's how attorneys develop I don't call it expertise, and Kentucky doesn't recognize specialties in the practice of law, but it is just having chosen to focus on a particular aspect of the law instead of trying to be a full service law firm. That has allowed me to, I believe, one, follow along with the law as it has developed. When you every year are trying to apply statute, and you are obligated just by a function of necessity to see what the General Assembly has done to tweak a statute, to see what the Department of Education has done to amend a regulation or provide interpretive guidance. essentially I've grown up with the law, and that has allowed me to, I don't have to research many things because I've just watched the law develop. So I know what the latest developments are. I know what the current guidance is. Other than that, I think there's some level of benefit to the fact that I grew up attending public schools. I attended public university. I attended a public law school. My wife has been an employee of the Jefferson County Public Schools. Other than having to quit to help us wind down the office, she's an applicant to become reemployed in the school district. My brother is a school administrator. His wife is a teacher. My dad did his student teaching before going to law school. I started my college career expecting to become a teacher. Realized schools are full of other people's kids and that maybe that wasn't my calling. Since I couldn't teach, I had to do. And that's been my career ever since.
Okay, thank you. The second question is, how many districts do you currently represent?
Of the dozen and a half that we represented as Dad was winding down the practice, about a dozen or so have determined to stay with me as we joined a new firm. There are a handful of others, like the Fayette County Public Schools, where they have a in-house counsel, but the board uses me on matters where she really is staff attorney and I advise the board. Lincoln County Schools, for example, have a local attorney, but I also provide services to them. And then there's several other school districts where we are insurance defense counsel. So my current client list that I had the relationship with as of the end of the year, start of the new year, is about 15 or 16. And by virtue of the school, of the board, the law firm that I joined, they have about another 11 or 12 that they represent. And we've started doing a little bit of mixing and matching. I've had opportunity to do some work on behalf of a handful of those districts that I've just been introduced to in the past couple of months. So the total client list for my new firm, it's working on 24 school districts that we have current contract with, and probably another half dozen that we do insurance defense work for.
Okay, thank you. Next question is, how do you define a successful partnership between the board attorney and the school board members, the superintendent, and the district staff?
That's an interesting question, just because by virtue of my history working for lots of school districts, I think most of my clients would say we have a successful relationship, but not necessarily any two of those relationships are the same. Usually I think a successful relationship is what works for the client, what fulfills the client's needs. In some districts, it truly could be a rare event that I speak to a board member and all of my contact is through the superintendent. In other districts, it could be a rare event that I speak to the superintendent and all of my contact is through a board chair. Most important in all of that is that everyone that I deal with understands that the board is my client. When I'm rendering advice, it is for the legal interest of the board. So if my primary contact is with the superintendent, I have to help them understand when we nut up against an issue where there might be a conflict of interest between what the board's legal obligations are and what somebody working on behalf of the board might want an outcome to be. Same thing with other administrators. There are a couple of school districts where the reason that we get hired as secondary counsel is because of personnel matters or because of special education issues. And in those districts, the only contact I would have would be that other administrator below the level of superintendent. Again, I think I would say I have a good relationship with those boards as clients because what I'm doing in speaking with those other employees is doing my best to protect the legal interests of the board and try to either keep the board out of litigation or to posture them for the best possible defense if we get into litigation.
All right, thank you. Next question is, explain your billing process, including rates, timelines, contacts, and any other specifics you might want to share.
One of the things that I always did, we always did when I worked for my parents, is it was important for me to be able to say we treated every school district client the same. So we had the same rate for Fayette County as we did for the small districts like Robertson County, Eminence Independent, Corbin, Harlan Independent. But because of that, we weren't asking the tiny districts to pay a big fee like what is a large district like Fayette County. We just had one rate that we believed was fair for all of them. But the contract was the same. From our point of view, it's an as-needed contract. If you no longer want our services, you can cut us loose. If we determine there's a reason we can no longer be in contract with you, we have to give you notice so that you can go through this type of process to find replacement counsel without leaving you in the lurch. Billing is on a monthly basis, $150 an hour for partners and associates. I believe it's $95 for paralegal work. I do bill for mileage and for the time of driving. That has been fortunate here this year of all these virtual meetings. I haven't had to keep track of mileage and bill for time on the road. Many times, if I am traveling for something, I will schedule an appointment to talk hands-free, but to talk with superintendent or special ed director or somebody so that and then I don't bill for the time on the road. I bill for the phone call or for the consultation time, so that I'm not just billing for sitting and staring out a window. But it's monthly billing at 6 minutes, 6-minute increments for a flat hourly rate.
Okay. Question 5 is, how will you ensure all members of the board are kept informed, especially in matters where there is a divided board?
It has been our practice with most of my school district clients to write to a superintendent and to just request a superintendent to distribute matters to all board members. As some of you all have experienced and some of you have just witnessed as you're new to the board, that has gone through some changes in Woodford County over the last couple of years. Some of that, I will say that I had perhaps some naivete as to what was being shared and what wasn't. Through recent discussions that we've had, I think you all saw an example of it yesterday, and I believe there's been a couple of others recently where it's fine with me to just send correspondence to all 5 members. You all have heard my conversations with you at board meetings about exercising caution about not turning that correspondence into a back and forth chain of email that becomes a discussion that would violate the Open Meetings Act. But really, my best answer to your question is just I want to do whatever works best for the board. And if that is going back to corresponding primarily with the superintendent for distribution to all members, that's fine. If the board wants a practice of the chair receiving all those communications and distributing it, that's fine. And if you all prefer, like what I did last evening, emailing all of the board members with the same item of correspondence, that's fine. It's not my role to dictate to the board how I communicate with you. I really want to be responsive to what works best for you.
All right. Question number 6 is, how many superintendent contracts have you assisted in negotiating, and what is your level of comfort in doing so?
I always hesitate to answer in a way that makes me sound Clinton-esque, but it depends on what the meaning of negotiate is. I've helped draft and revise a bunch, but as far as what I would call negotiating a contract, meaning that you give me a dollar authority and you're asking me to go back and forth with benefits, packages, and dollar figures, I've really only played that role maybe twice, and one of those I would hesitate to say that I was fully authorized to negotiate to a conclusion. But as far as sorting out details and revising contracts, it's been more than a couple of handfuls that I've been involved in over the past decade.
Okay. how would you describe your communication protocol with your school board clients when you have pending litigation or open matters? Would you say that you are easily accessible to your clients?
Easily accessible, yes. I've done, throughout my career, I've done my best to make sure folks have email addresses, cell phone numbers, and to know that you can pretty well get a hold of me any time of day. If my phone rings and I'm available to answer it, I will answer it. If I'm not available to answer it, I do my best to return texts, calls, and emails quickly. Just if we need to schedule an appointment, or if I need to ask questions before I can render advice, I try to do that fairly quickly. When the board is involved in litigation, again, I can't say that there is a fixed protocol. If there's something, for example, like on a construction matter, where post-construction there's problems with it, which I know we've had in Woodford County previously, but not any currently on some old building matters. My communications about that progress of litigation is with the board. When the litigation that I'm involved in involves personnel matter, most of that would go through the superintendent, HR director, and the board would really only become involved if there was a major status update, or if there was a time to discuss whether we need to settle, whether we ought to file an appeal. Otherwise, my communication would primarily be with the figures who are involved in that area. So, special ed director on a due process hearing, even if that becomes litigation. Facilities manager, if we're involved in some litigation on facilities or slip and fall, if there's an injury at a school and we're involved in that case, we would communicate with the people directly involved, and usually only communicate with the board collectively when there are major decision points or major events in the litigation.
Okay. Question 8. Do you have experience with new or new to district superintendents in helping them acclimate to the policies and procedures of the district?
I do, in one respect, in a unique way. Right at the same time I had passed the bar exam and started practicing law. Some would say I started practicing law with a license, but when I started practicing law, there were a handful of school districts who hired new superintendents all around that same time. So Robin Cochran in Washington County, and Jimmy Evans in Lee County, and James Nyhoff in Shelby County, and multiple others who I won't even recall off the top of my head. Sheila Mitchell in Anderson County. Many of them were brand new superintendents at the time. So I had the opportunity to kind of grow with them and learn what it meant to them, what they were perceiving as a new superintendent, learning the ropes, what they needed from me as an attorney, and what growing pains they had as they grew into the role of interacting with council, interacting with Board of Education, interacting with their subordinates, including many times if it was somebody promoted from within, their peers had now become their subordinates, and that was a dynamic to be explored. So there have been other school districts, some of those districts have hired new attorneys since then, and I've worked with them. But I think I'm uniquely situated in that regard of having kind of grown into my current role. At the same time, a couple of handfuls of superintendents were growing into that role as brand new superintendents.
All right, thank you. When working with parents or guardians, as well as adult students, what is your experience in directly supporting ARC team members in meetings to resolve concerns and conflict? If an ARC is unable to resolve the conflict or concern and a formal complaint is filed, what's your experience in meeting regulatory timelines?
I have attended more ARC meetings than I can remember or even come close to counting. Quite frankly, special education law is probably my primary love in the aspect of law I get to deal with. From special ed directors down to ARC chairpersons, all the related service providers, the teachers. Many of them are uncomfortable in that formal setting, especially if a parent has an attorney. And the opportunity to meet with them ahead of time to prepare them for what that meeting is going to look like, what we're trying to accomplish. The parent is probably hearing from their attorney, or if the parent doesn't have an attorney, just my experience in other similar situations of being able to say, here's why I think the parent is at this decision point, or why I think there's a conflict brewing. Here's how I think the parent is looking at it, and here's how I think we can mend a relationship or fix a miscommunication. So I have significant experience in that regard. I think I'm pretty decent in that role. Don't always trust what opposing counsel says, but I have had opposing counsel tell their client that I'm not full of it and trying to pull the wool over their eyes if I participate and speak in one of those meetings, that I am doing my best to resolve an issue in a way that doesn't shortchange the kid. Unfortunately, many times you can't solve a matter. Parents or their attorneys think that there's more that you're obligated to do, and our advice is that you're not obligated to do it, and we do end up with a due process hearing or a state complaint. And I have, on behalf of probably 12.5 districts, I have responded and participated in various levels of the administrative proceedings, OCR complaints from the United States Department of Education, state complaints to the Kentucky Department of Education, due process hearings, and just navigating those timelines, the requirements, the briefing requirements and filings is just part and parcel of what we do for every handful of districts.
All right, thank you. Given that issues often arise unexpectedly that need attention, generally speaking, what is your availability to respond to school district personnel questions?
It's not good to just start a phrase with I do my best to allow superintendents, HR directors, principals, where that's appropriate, to just know how they can get a hold of me, to have my cell phone number, so that where something comes up that they need an answer right now, today, we just heard of this and the employee is on their way to my office, I try to be as responsive as I can to walk them through the process. So I can't say that I'm available 100% of the time, because I have a lot of clients to juggle. But particularly if it's clearly communicated to me, we have an urgent matter, we have a developing matter, I do my best to get away from something else if it can wait, so I can devote attention immediately to the urgent matter. And with the benefit of the firm that I've joined, I'm not just out on my own. Jonathan Shaw, a partner, and Sean Conley and John Porter, who are both in that firm, all represent school districts throughout eastern and east central Kentucky. And if there's something where I truly could not pull myself away, I would be able to fairly quickly get the client in touch with one of them in the hopes that that they would be able to walk through that process in my absence.
Okay. And our final question is, approximately how much of your professional time is dedicated to school legal issues?
If you're rounding up, it pretty quickly rounds to 100%. There are occasions where, even already here these couple of months in my new firm, where I've been requested to research specific issues relating to a fiscal court matter or some community agency type matters. But other than those isolated, can you research this topic, all of my time is devoted to representing public school district. Those other matters that I've become involved in, even those, my mind isn't completely taken away from public school districts, because all of them are also other public entities, and there's so much overlap in areas of law that even doing some work for those type of entities, it is providing me more knowledge about if the same issue popped up for one of my clients, I would be prepared. Very rarely is there zero overlap.
All right, thank you. Gonna open the opportunity up for any of our district personnel to ask any follow-up questions that they might have. Mr. Hawkins? You guys good? All right, hearing none. Ms. Springate?
No, thank you.
Ms. Richardson?
No, thank you.
Ms. McHale?
No, thank you.
I'll take that. And Ms. Glass?
No, thank you.
All right, Mr. Chenoweth, we thank you for your time and your expertise and dedication to the students of Kentucky and especially to the students of Woodford County.
Thank you all.
We will conclude the attorney interview and move on to our next regular agenda item, if that's agreeable to you.
It is.
All right. The next item on our agenda,
I need to put Don on here.
he's available by phone tonight.
Okay.
So if we have any questions, I think Grant has his number, or Mr. Hawkins or I can reach out to him. He had another board meeting tonight. The agenda item is determine minority representative election process and timeline for the superintendent search committee. Mr. Chenoweth, if you want to go through a little bit about what you shared with us by email.
Well, I'm getting that pulled back up on my screen so I don't have to try to do it from memory. So the way the superintendent selection process works, you all already started down that road. When the vacancy is declared, you're supposed to appoint a screening committee within 30 days. And we are just past that deadline. You all have had the kind of statutory trigger where you completed that process at your last board meeting with the designation of the board member. And then it was determined that this subsection of the statute kicked in, which if none of the 6 required roles, if none of those members is a minority member of the screening committee, then the law requires the board to do a special election of a minority parent to serve on the screening committee. So that part of the statute has been triggered. The statute defines what minority means for purposes of this minority parent election. For the benefit of your constituents that are listening, that is the same, my belief is it's the same definition for the minority member of the school-based decision-making council. And this process, quite frankly, is very similar. If a school-based decision-making council does not have adequate minority participation based on minority percentage in a school, there's also a minority parent election process there. And the minority definition is the same. It's American Indian, Alaskan Native, African American, Hispanic, including persons of Mexican, Puerto Rican, Cuban, and Central or South American origin, Pacific Islander, or other ethnic group underrepresented in a local school district. That definition and the requirement to conduct the election are just about all the statute says, and then says that the Board of Education the minority parent members shall be elected by the parents in an election conducted by the local school board. So you all, without any regulatory or statutory guidance to help you, have the obligation to figure out how to do a fair parent election district-wide, how to solicit nominees, advertise the election, and try to encourage as much parent participation in that vote as possible, but on a fairly abbreviated time frame, so that the work of the screening committee is not significantly delayed by this process. I think your application deadline right now, I think was discussed at the last meeting, is March 12th. I think it would be a good idea to make sure at the very minimum that you have this process completed by that same time, so that as soon as all the applicants are in and the screening committee can begin its work, that you have the full complement of required members for the screening committee.
Okay, thank you. Mr. Hawkins, can you tell us, or Ms. Cooper, what was the time frame that we made open for other areas on the committee?
For the nominations, we gave approximately 1 full week. For the ballot, because we had a snowstorm in the middle of that time, it was a little over a week. So the nomination process was about a week, with the ballot process a little over a week.
Okay.
A week and a couple of days, something like that.
And the ballot process was extended because of the snowstorm?
Yes.
What was it set to be before that?
Well, we were wanting to do it on that Friday, but we ended up making it that Monday instead.
Okay. And as far as advertising, that was done just by an email to the different groups, correct?
Correct, because we were dealing with staff,
Sure.
so we were able to do that through our work email account.
Okay. And Mr. Gibson, can you tell us a little bit about how you anticipate this working as far as contacting all of our parents or guardians and making them aware of this?
Well, there's several methods we could use. The Infinite Campus email system is one, because all parents are located inside of that. The one-call system could be used as well. Teachers through their normal process could, but that's not advantageous usually. It's usually best to go through one call or IC. Those would be the two best ways, and then you could put an announcement or something like that on the website as well.
And can we send a mailer home with the students as well?
Probably.
Grant, do you feel like those methods that have been discussed adequately advertise the position?
Yes, especially if that's the same method that's been used on other processes. I think that's always the good thing to be able to say is we did the same on this as we did for other positions. Did you have something, Ms. Richardson?
Yeah, I was just gonna ask, would it be adequate if we started advertising for that tomorrow and close it out on Monday, the 8th? That would give us a full week, and then we could vote early that week and have it wrapped up by the 12th?
I don't see anything wrong with that timeline. That's certainly for the board to discuss. I think there's always a benefit to allowing that advertising. One of the things that you need to discuss is how long do you want to solicit nominees versus then once you've received nominees, how long do people need to know who the candidates are that they're voting for? It's kind of a two-step process to get done before the election. One is to solicit nominees, and the second is then to say, now that we know the nominees, now here's the way to vote.
And another thing that we discussed, we had a phone call with Mr. Chenoweth, Mr. Martin, Mr. Hawkins, and I in arranging tonight's agenda item for this. And one of the things we discussed was that we do need to hold both virtual and in-person voting for our parents that are, don't have access to a computer. We need to make sure there's an avenue for them to vote in person during a certain amount of time, and then to discuss the safeguards on that to make sure that it's just one vote per person. That's another question, Mr. Gibson. Does Infinite Campus, if you use that, are you able to just have one vote per parent?
No, that will go out to both parents that are listed as kind of the primary contacts 1 and 2.
Okay.
And there's nothing that comes back to us through that system in order to indicate what they did with the information. What would is if we send out a link to vote or to solicit nominations, either one, through through a Google form, then we would get that data back, and then we would be able to match it up. But it's still, because email addresses would be coming in from all different services, there's no way for us to lock it down to anything, because you could represent yourself as a different email address, and there's nothing really collecting that to then exclude you in or out.
Okay.
So,
but as far as voting, once everybody has submitted the names or nominees for that, then if there is a link sent out, there's a way to make sure that that link is only used once.
No, it's the same problem. We can do internally, we can do that. But once you start bringing in other services outside of Google, you can't guarantee that. It's more of an honor system piece.
Okay, and is that acceptable, Mr. Chenoweth?
I think it is, in part, just by the rule of necessity, that's the technology we're dealing with, and we can't really set up a system like the Board of Elections would, where we're checking IDs and checking people off of the list. We wouldn't have any signature to compare if we were requiring people to sign paper ballots. We don't have a batch of original signatures to compare them to, so we do, essentially, we're distributing this out to our mailing list of people who, as Mr. Gibson said, are listed in our system as parents. And it is, in some respects, we've got to rely on the honor system, that asking that each individual only vote once and that nobody vote unless they fit the definition of parent, which is slightly broader than just, it's not biological parent. It can include those who are the primary caretaker of a student that serves in the role of a parent in the absence of a parent. So it doesn't have to be the legal relationship of legal custody or foster parent or adopted parent. There can in fact be somebody who fits the definition of parent if they just serve in that primary role for a student in the district.
Okay. Give each board member a chance to weigh in with any questions that they might have. Ms. Springate?
I don't have any questions, but I would say it is very, very important to make sure that the information is out there. I know this was put on kind of last minute, so it's really hard, I think, for people to know kind of what's going on with the process, even if you follow very, very closely. So I do think that's, just of utmost importance, is to make sure people understand this is an option, this is going on, and we would certainly like, multiple nominees.
Okay, thank you. Ms. Richardson?
I agree with Ms. Springate. I think that it is important to get it out there and let people know that this is what we're doing. I think that we also need to be very focused on the fact that, everything that we're doing in this process, time is of the essence. And I think that the people who do put themselves out there and want to be a part of this are obviously forward and forward moving, and they want this to be a good process and they want to take part in it. So I really think that we need to try to make sure that we do this within the next week and meet our deadline of the 12th. I think that that's very important. I know that we had some minorities who did sign up to be the parent representative, so perhaps some of them will be interested in doing this as well, hopefully. So that's really all I need to say, is just that we really need to stay focused on the fact that we need to move forward, and we need to do it as efficiently and fast as we can to make sure that we move forward with the process in a timely manner.
All right. Thank you very much. Ms. McHale?
I would have nothing in addition to what's already been said. I do agree time is of the essence, and getting a good, diverse pool of people is, that's much better, is important. So whatever we can do as a board to help facilitate that, getting the word out through different organizations, I think would be helpful as well.
All right. Thank you. Ms. Glass?
Nothing really else to add. I guess I'm looking at the calendar. So I know the job closes on the 12th. So is it a possibility if we, like Ms. Richardson was saying, we posted it tomorrow, we accept nominations until the 9th, and we held that through the 12th and then had the voting maybe either on the 12th or the 15th? Does that throw it off by, because I think the first meeting of the screening committee is the 23rd, correct?
Yes.
I didn't know if that would, that would give 4 days, 5 days for voting, and 7 including the weekend, if we close it on the 15th. Does it have to close before the application deadline, or at the application deadline?
I think we can certainly call Mr. Martin and let him weigh in on that, but Mr. Hawkins and Mr. Chenoweth, I think what he's shared with us was that Katie is definitely not looking over our shoulder at getting this done in a hasty time frame, just as long as we're making the effort to move forward with the process. I think that the 15th is probably a good target. Mr. Hawkins, what do you think?
really think it's up to what the board wants to do. I think to me, the key piece is, do you, can you combine, once you get nominees back? I think when we did it before, we had them write a paragraph or something about why they were interested. If all of that information gets submitted as part of the ballot, at least people can review that, while that is going on. So I don't know that you have to treat those as two separate entities, that you send out the information and then you send out the ballot later, because I think it would be best to do that all at once. So ever how you want to do the time frame, I think that's up to you, but I don't know that you need to treat it as two separate pieces.
Okay. And Mr. Chenoweth, do you have language for us to use so that we make sure that we are in compliance with the statute in what we send to our parents and what we put out in advertisements?
I do. It's largely the paragraph of the statute that I quoted in my email to you all, and then the clarification, just to make sure the public understands, because it's a question that comes up regularly. To be a nominee, you have to be a minority parent, not just a parent of a minority student, but all parents in the district are eligible to vote. So it's not just a election by minority parents of a minority parent. It's all parents electing a minority parent. But those are the clarifications that, if nothing is stated in the communication, those are the questions you end up getting bombarded with after the communication goes out.
Graham, it would be helpful if you could just send an email that said, this is what goes in the body of the email. And we'll do our best to get it out tomorrow. The one thing that we will need to do is get it translated so that it goes out not only in English but in Spanish as well, because we want to make sure that every parent has the opportunity to participate. So as quickly as we can get that turned around, we will do so.
I will intend to email you all before I call it a night tonight after we get off the computer here.
Thank you. Okay, then we will go forward with a time frame of having it open until Monday the 8th, and then publicizing the candidates or nominees, and then try and open voting for the 11th to the 15th. You don't want to do that way?
I don't think you'll need to do that as two separate pieces. When you say to advertise, I think if you send that all out as once, to say, here are the people who have been nominated, here's your ballot. So they have a chance to review that. The way I understood what you said is to send it out as two separate things.
My two separate things are just, here is what we're going to have to do, and then the second step is these are the people that have applied.
Right, but I understood the second piece that you had was two steps. It was to say, here are the candidates, and then 3 days later.
No, I'm sorry, I misspoke.
Okay.
I didn't mean it like that. I just meant the two steps. One, here's what we need, and then here's the applicants in the ballot, or here's where you can vote in person during these times. But yeah, I agree, just 1 and 2. Sorry.
So I'm sorry, how long do we think that we would need to convert that sort of list of candidates to the actual vote? Because I'm thinking if it's not a lot and we do it in one step and have their information at the time we have the final listing, could we open voting up, say, on the 10th for a few days?
It's really going to depend on how many.
Yeah.
I think the last time there were 40 or so
Okay.
parents.
45 to 49.
Wow.
I don't think you'll be able to turn that around necessarily in a day. So,
Okay.
If we close the nominations on noon on the 8th,
Okay.
that would give an extra half day built in to prepare for the next ballot. Would that be acceptable?
The question was, Ms. Cooper asked if we were to close nominations at noon on Monday the 8th, that would give an additional half day for her to work on putting together the ballot with the candidate information. Is that acceptable, Ms. Springate?
Yes, that sounds fine to me.
Ms. Richardson?
And so the ballot would go out on
as
The
soon
ninth
as
or the
possible
10th?
after she gets it all.
Okay. Okay, yeah, that's fine with me.
All right, Ms. McHale
Yep, that's fine with me.
and Ms. Glass.
Sounds good to me.
All right. Does anybody have any further questions or comments?
Just a question, how then do we accommodate in-person voting for this? Or have we just not gotten to that discussion yet?
Before we get to that, how long did you want to leave the ballots open?
What's your recommendation? Or how long did we leave it open for the others? We said
Well,
a week?
If you, just looking at it from a timing standpoint, if nominations are due by the 8th, and it takes a day, day and a half to get them turned around, they're going out on maybe the 10th.
Mm-hmm.
When do you want to set the deadline?
Why don't we set it for noon on the 15th? And that way there's time to count them before the planning meeting that night. Is that okay, or do you have a different thought?
I mean, we're fine either way. I think we just need to set those parameters.
Okay. Go ahead, Ms. Cooper.
I just will clarify, the paper ballots will take time to input. The electronic ballots are an easy cut and paste, but anything that comes in on a paper ballot will have to be hand typed. That will add time.
Okay.
So if we get 100 of them, I'll work as quickly as I can and give you an update as I'm doing them.
Well, and I think if we anticipate closing paper ballot voting on Friday at noon and then electronic at noon on Monday, if that's acceptable to you.
That would help give me another half of a day to work on the paper ballot.
Okay.
I don't know how many we're going to get. I'm just trying to think in advance.
Or, and I mean, if it's,
I think you want to be careful because you're offering the paper ballot to those who may be underserved, and you're giving them less time than the people who have access to electronic means. And I think that is not necessarily the right message.
that makes sense, thank you.
I type fast.
Sorry, you type fast.
Well, I do think just to that point, it's good. I got my calendar out just to kind of look at the times we're throwing out because I'm more of a visual person. So basically what we're saying is we're hoping to have the ballots out on Wednesday the 3rd.
10th.
I'm sorry? I mean, to have the announcement, just the announcement out by Wednesday the 3rd, right?
It could go out tomorrow, but Wednesday would be the latest, I
Okay.
would think.
So either Tuesday or Wednesday to get the announcement out. And then they would have, maybe we'll say Wednesday, Thursday, Friday to do their paragraph and submit their name. And that would close Monday at noon. So that's, 3, maybe 3.5 days. And then we would have the ballots out hopefully by Wednesday the 10th, but then they would have to be back by the 12th for in-person voting. So they probably would have Thursday and maybe till noon on Friday to vote in person, and then till noon on Monday. So if you look at a calendar, it sounds like the dates are kind of further apart than they are, just kind of glancing at it on here.
To Mr. Hawkins' point, should we then cap all voting at 6 o'clock on Friday or 7 o'clock on Friday to allow people, if they need to come, do in-person?
Nothing is open at 6 or 7 o'clock.
I wouldn't shorten the window.
Wouldn't or would?
I would not.
Maybe make it the same.
Because again, I think you're wanting to try to send the message that we want as many people to participate in this process as possible.
Sure, and that's why I was.
If it doesn't go out until Wednesday,
A day
and
and
they
a
have
half.
until Friday, that's not much time to really participate. And
Okay.
so, to me, if I were to do it, I would say close the business on Monday, and then we'll try to get the results done as quickly as we possibly can.
Okay, and then will we be able to have, an opportunity for people to go vote someplace from 5 to 7 on one of those days?
I would think what we could potentially do, is, I think if you had ballots available at each school site, so that, you know, if someone comes in, they can complete it there in the vestibule, turn it back into the school staff. We could potentially keep our office open maybe until 6 one of the nights, if we needed to. So that would give folks another opportunity to do that.
That'd be perfect, thank you.
That would be consistent with how we have handled SBDM elections and those types of things.
Okay, I think that's important, having that precedent set. All right, Ms. Cooper, do you have any other questions?
Are we confirming noon or close of business on the 8th for the nominations? We've said both tonight.
I said close the business on the voting, so I don't know about the nominations.
Okay, so you were talking about voting. Never mind. Okay, sorry, I missed that part.
That's okay. All right, so we will have the nomination information go out, hopefully tomorrow, but maybe Wednesday. Then voting will close, or nominations will close at noon on 3/8. And then we will have those ballots emailed as soon as we can. And then voting for in-person or electronic will be concluded at 5 o'clock on Monday, March 15th. And then those results will be made available to the public as quickly as we can get them turned around.
Clarification. 5 o'clock, there's nothing open in the system at 5 o'clock. If we make that the night that we're gonna stay open late, we could be open till 6, but that's a board meeting night for me. So there's none of our buildings are open till 5 o'clock.
What time is close of business?
I mean, it's typically 4.
Okay,
is what we're
sorry,
saying.
I was thinking 5 o'clock for
But
close
if-
of business,
yeah,
so
if we
4
wanted
is
to
fine.
make that night late, we would have to have somebody from central office be there or make it a different night to be open till 6.
Okay, we'll just do 4, that's fine. I was
I'm sorry.
no, I'm happy for the clarification. So that will change to 4 o'clock, but everything else will stay the same. Mr. Chenoweth, does that all sound like we are adhering to the statute?
It does. As I say, there's no details. I have not participated in the screening committee preparation meetings and discussions that you've had, so I didn't know how soon after the application for the superintendent candidates closed that the screening committee was going to convene. With what you all shared tonight, that I think having a nomination and voting process done by the 15th is plenty of time.
Okay, very good. Is there any other comments, Ms. Springate?
No.
Ms. Richardson?
No, ma'am, thank you.
Sure. Ms. McHale?
Nothing from me, thank you.
Ms. Glass? No, ma'am. Mr. Hawkins? All right, then is there a motion to adjourn?
So moved.
Is there a second?
Second.
There's a motion by Ms. Springate, a second by Ms. Glass. All those in favor, please say aye.
Aye.
Aye. Opposed? All right, thank you all very much.
Thank you all.